Okay, ladies and gentlemen, I'd now like to welcome our next session, Andrea Wilson. Andrea has been operating here as a family lawyer and a migration agent practicing in Sydney. Her first experience co-parenting matters for lesbian mothers began in the family court in 1993, some 20 years ago. Pushing the law and the state legislation change, so allowing the second mother's name to be actually registered on a birth certificate. Now, since then, Andrea's been working with a number of both heterosexual and gay couples throughout Australia and supporting their requirements in terms of legal matters and birth certificates from other states that have also followed the New South Wales legislation. Her practice that involved both in Australia and overseas, and she's acted for intended parents since as early as 1997. I think this area is a really important area for people to understand what they're getting into with the legal sort of jargon, and also the nightmare that you'll enter. And the better informed, the more smooth the whole arrangement will go for you. Please welcome Andrea Wilson.
Thank you. So this topic is about parenting orders in the family court, whether they are a necessity, and I'm just going to say straight out.
You can't hear you.
You will.
Everyone's connected with help, wouldn't it?
So, this is about parenting orders in the family court, whether they are a necessity. I'm just going to say outright they are at the present time. I'm going to begin by saying that every child has a right to have his or her parents legally recognised. If a child is born in Australia from a surrogacy arrangement, then the child's intended parents can apply for a parentage order under state surrogacy legislation, which, if all requirements are followed, will be granted, provided it's an altruistic arrangement. Change things around because I realise that one of the parties is going to be speaking on citizenship. So with the so let me just going back to children being legally recognised, this is not the case in Australia. Children raised following a surrogacy arrangement, if born offshore from, say, commercial surrogacy arrangement, do not have the certainty of parental status. So we look to, in these cases, we look to the Family Law Act, which is Commonwealth legislation. Interestingly, in that Act, there nowhere is the word parent defined in relation to surrogacy arrangement. There is a section, and this is a minefield, this whole area. I've been in court where we talk for quite a few hours just on one section, so I'm really going to make it quite simplistic, but I'm hoping I'm going to get the message across. There's a section in the Family Law Act which deals with presumptions of parentage of children in surrogacy arrangements. The heading is Children Born Under Surrogacy Arrangements, and if it's section 60HB, and if the court has made an order under a prescribed law of a state or territory, then the child is the child of each of those persons. Now, this is relevant because the state legislation is for each state is really where we're looking with respect to parentage. So also with that, with the presumption of parentage, it applies to the surrogate mother and her married or de facto partner. The proviso is also both if the woman and her married or de facto partner consented to the carrying out of the procedure, an artificial insemination procedure, and the woman and her married or de facto partner were in that relationship at the time of conception and must be under a prescribed law of the Commonwealth, of a state or territory. then that presumption is the child of the surrogate mother and her married or de facto partner. So this is whether whoever has provided the genetic material. So even if there is a sperm donation or the sperm's been provided, if the sperm's been provided by the intended parents, then it's still the case that the surrogate mother and her married or de facto partner will be presumed the parents. So this is the presumption under the Family Law Act. So we've got an inconsistency between not two, but pieces of legislation, state and Commonwealth. Now, what happened is the Standing Committee of Attorney Generals decided that they're trying to rectify this by bringing in the surrogacy acts in each state, which transferred the parentage from the surrogate mother and her married or de facto partner to the intending parents. But this doesn't apply where children are born overseas under commercial arrangements. So there can't be a declaration or transfer of birth certificates through the state birth-based marriages. Now there's another section in the Family Law Act which again causes this is probably what a lot of people are relying upon and where they need to get parenting orders. That it's in relation to registration of birth, and the section in this Act, Family Law Act, is section 69R. The heading is Presumption of Parentage Arising from Registration of Birth. It says, if a person's name is entered as a parent of a child in a register of births or parentage information kept under a law of the Commonwealth or of a state, territory or prescribed overseas jurisdiction, the person is presumed to be a parent of the child. Now, so what we have here, what I pick up is the words prescribed overseas jurisdiction. Now, that is a minefield, and most of the major surrogacy destination countries are not prescribed overseas jurisdictions. So then we have, and I am going to touch on a little bit of the citizenship by descent. I'm also a migration agent, but I'm just trying to put it in perspective of what's happened historically. So ordinarily, our primary documents are a birth certificate and a passport, but it actually doesn't deal with parentage. But with that, you can get a Medicare card with the name of the child. You can get parenting payments from the Australian government and a childcare rebate, but it still doesn't deal with parentage. And I guess what I'm meaning by that is it's not extinguishing the rights of the surrogate mother overseas. They can still be a parent. So, just with the citizenship by descent, what happened is, following a few cases in the family court, the family court and federal government, with the the Department of Foreign Affairs and Trade, following a lot of submissions by the family court and the federal government, brought in April 2013 a requirement that the surrogate mother's consent in writing to the issue of an Australian passport was required after the granting of citizenship by descent by DAC, so that they expressly require the consent of the surrogate mother for that purpose. And also, secondary to that is that they also require the consent for the removal of the child from the country of birth. So that's how they have got around this a little bit. But there are forms that if you can't locate the surrogate mother overseas, we've got around that. So, prior to that, it was that under the Australian Citizenship Act, they recognised more or less the intended parents and overlooked the surrogate mother. So, and that just with that requires the consent for each passport application while the child's up to 18 years. All right, so then back to the parenting orders in the family court. So this is the case because, for instance, a gay couple may be unable to both be listed on a birth certificate from India, and for a heterosexual couple, depending on which area in India, if an egg donor is used as the surrogate mother's name may be recorded, where ordinarily both can be listed as the parents. So it's not just for gay guys. And in Thailand, the birth document will list the birth mother as the genetic parent if the surrogate does not have a husband. So also, all states will exclude commercial arrangements, and most exclude children born outside the jurisdiction, and may not do so where the parents were not in the jurisdiction at the time of birth. So these are some hurdles that have got to be got through whichever court you go to. So I was involved in a decision last year. It was Mason and Mason, and in Sydney, this particular judge decides to hear these cases, and we've done, we tackle bits of the law as we go. I'm just recapping on the citizenship by descent. That basically is that what they were doing was adopting the Section HB of the Family Law Act. So this, the case that I was involved in, that was a pseudonym by the name Protecting the Child's Rights, but interestingly, they're not happy to sort of recognise parents, even though I was pushing for a declaration of parentage. But they allowed the two gay guys in this case to openly give evidence, and they got protection under Commonwealth legislation for talking about the whole arrangement. There was a case in 2012 which was Allison and Khan Shannon. I'm not sure if I'm pronouncing that right. This was a case where the Human Rights and Equal Opportunity Commission was invited to participate, and this particular judge formulated what she considers to be a best practice outline to provide guidance in future international surrogacy cases in the family court. Now, her approach, it's quite extensive, and so each point when I go to court, I try and challenge each point, and I ask for waiver of certain things. And I try and put as much material into the affidavit so that we don't need this. But her practice is, for every case, that an independent children's lawyer be appointed to represent the child's interests. The affidavit material must be from the applicant and the surrogate, or applicants, addressing the circumstances leading up to the surrogacy arrangement. It's pretty bloody obvious, isn't it? We've got two gay guys. The procedure itself, birth of the child and subsequent arrangements for the care of the child, fair enough. Independent evidence regarding the identification of the child, including the surrogacy agreement. A certified copy of the child's birth certificate, parentage testing in accordance with the regulations, and evidence of citizenship. Then, independent evidence concerning the surrogate mother from a family consultant or an independent lawyer, including information that she received legal advice and counselling prior to entering into the surrogacy arrangement. The surrogacy arrangement was made with her informed consent and entered into before the child was conceived. And then after the birth of the child, the surrogate's views about the orders being sought, and including what relationship, if any, she proposes with the child. Now, also, whether she can participate in an interview with an immigration official prior to the grant of a visa or passport. And then also, we haven't finished yet, the preparation of a family report. Now this is, I am absolutely just, it just sickens me, this one. Addressing the nature of the child's relationship with the person seeking parenting orders and an assessment of their capacity and commitment to the long-term welfare of the child. Including their capacity to promote the child's connection to their country of birth, fair enough, including but not limited to the birth mother, and the views of the surrogate, in particular her consent to the proposed parenting orders, and evidence of the legal regime in the overseas jurisdiction. Okay, that's fair enough. Now, comparing that to state legislation for a parentage order. Okay, now this will enable the change of the birth certificate. There is an affidavit from the solicitors, pre and post, for all parties, pre and post counselling, and an independent counsellor's report. Affidavits from the intending parents as to similar matters raised in the family court, but not as extensive as that. More about, what's in the best interest of the child, what's happening, what's happening in the family at the time, but not judging them as to parenting capacity. Also an affidavit from the surrogate mother and her partner, if she has one. And then registration on a central registry with the Department of Health, but no hearing. So, these matters, we go to court quite a few times for the one particular, to get the parenting orders. We'll always get it, but there's quite a few hurdles at the moment. But there is the necessity to remove the parental responsibility from the surrogate, and for her to give those rights to the intended parents. So, it's no wonder that people rely upon the primary documents and decide not to go down this course of action, but because it's just the family report, they deal with about 29 issues. I've seen reports that are like 35 pages long, and really going into stuff that is just unnecessary. But the, and also because the uncertainty, the stigmatization of the family form, the threat of criminal sanctions possibly that have been mentioned sometimes in some of these cases, renders it, presently undesirable for a lot of people. So I just, so for me, I question the necessity for an independent children's representative in these cases really at all. I don't think there's ever will be a need for this, and I question the family report. I think we can, okay. So this is particularly in matters where already the intended parents have been the primary caregivers for quite some time. So, okay, I also just wanted to say that I'm probably pushing for declaring that a person who provides genetic material, I think there should be a transfer of parentage, and that could be done before birth. I'm probably also moving to make commercial surrogacy arrangements legal. I did have some other things, but okay. So, any questions? Yes.
Microphone here. You mentioned Mason 2013, which you said you were involved in.
Yes.
So that was gay dads, so I assume they were involved in a commercial arrangement overseas. So I'm just wondering how you go to New South Wales State Court for parentage orders in circumstances where obviously to do so you're admitting to the court that you were involved in this arrangement, which is prohibited in New South Wales.
Yeah, no, we can't go to, that's the whole point, we can't go to a state court, so really we're still under family law jurisdiction.
So it's a federal court application?
Yes, yes. Yeah. Oh, it's done through the family court is Commonwealth legislation, so it can be done in any state except Western Australia who have their own family court.
And have there been any, in an application like that, is there any referral to the DPP?
Yes, there have been a couple of cases, but nothing's happened. And I mean, when you look at the statistics that we know of, being about 1,000 that we know of that have been recorded, I mean, you know, there's going to be all these children, and both courts, all the state courts and the family court, it's always about the child, so they're always looking at what's in the best interest of the child. So you're not going to, this isn't, my take is it's not going to happen.
Sure.
Yeah. But well, they would have actually done something a long time ago because the numbers are just more than increasing, doubling, yeah. You know, going up like that. Yes.
Another question. If one goes for an overseas surrogacy and the surrogacy program is conducted as per the state law, all the provisions of expenses which are allowed are taken care of and the program is conducted accordingly, then will that be considered, will that be program recognized as a true sex surrogacy, or will that still be commercial? Am I able to?
I'm not sure that I'm getting your accent. Sorry, I'm from here.
Please repeat that question again.
Yeah. If somebody is taking and enrolling under surrogacy program in a country overseas,
Yes.
and the program is conducted as per the state law of Australia.
Okay.
Program?
Yeah, the program, the surrogacy program is conducted as per state law.
Yes.
Yes.
All those conditions which are there under the statute are taken care overseas. So will that program be recognized as a true sex surrogacy, or will still the government take it as a commercial surrogacy?
This goes back to whether that particular country is a prescribed overseas, has prescribed overseas jurisdiction. So maybe that's the other thing, I'm sorry, I did have that down, but maybe what we need to be tackling is, while these countries are developing their ART legislation, that we need to be getting involved in that so that they become a prescribed overseas jurisdiction and therefore recognised. So there's quite a few ways we can go here, but it's going to be a process. And I'll talk to you further if I haven't actually answered the question.
Can I ask one question, because we need to move on, but I know when I was in America, we applied for a citizen by descent through the embassy in Washington,
Yes.
which we were able to achieve.
Which we can do that in India anywhere.
So they can be done anywhere. So what is there?
Immigration's fine.
Yeah, okay.
Yeah.
So in terms of advice for intended parents, or is it better to go for a citizen by descent while you're overseas, or are you better off trying to get a local sort of birth certificate and then trying to convert once you come back to Australia? Is there a review around at the moment?
Citizenship by descent. Easy.
While you're overseas?
Absolutely easy, but
Okay.
what I'm saying is it doesn't give you parentage.
Okay, even if you get citizen by descent?
That's right. That's my whole point. You're still not a parent.
Right, even if both parents are listed on the actual...
That's right. Unless you have an order from a prescribed overseas jurisdiction,
Yes.
where the consent has been given by the mother, not only to the amending of the birth certificate
Yes.
but that you have an order that the consent of the surrogate has been given to remove the baby.
And certainly our experience in America was exactly that. The mother consented through a court order.
Yes.
and therefore my wife Renata and I
Easy.
will put on the
Yeah.
birth certificate. So
Citizenship
maybe
IC.
I'm not sure, but is it easier in America to do that, or is it easier? It's much the same in most countries.
Immigration is fine.
Okay.
And I just want to say, good luck to everyone
Yeah.
on your journey and for the surrogates and
Thanks, Andrew.
teddy parents.
Wonderful.